right. Thank you everyone for joining us today for our webinar on E-2 visa to green card options and considerations. My name is Dustin Saldariaga and I'm an associate at Scott Legal PC. If you're here today, you likely already have an E-2 visa or at least considering one, and you're in good company. Our firm was actually founded on an E-2 visa about 8 years ago by Ian Scott, who is joining us today for this webinar. Our firm has a focus on investor visas, and we've actually processed hundreds of them. We've also helped some of our clients move from an E-2 visa to a green card. And that brings us to what we'll be speaking about today, which is the various green card options that are available to those who are on an E-2 visa. A few things before we get started. This webinar is part of a series that we will continue by doing at least 2 webinars a month on various immigration topics. We already have a number of webinars scheduled, and we will be regularly adding more. At the end of this webinar, we'll be sending you all a few things. First, we'll send the PowerPoint that we'll be using during this presentation. We will also send a link to where you can sign up for our additional future webinars. And since this webinar will be recorded, we'll be sending you a link to the webinar. A few housekeeping items before we get started. We do plan to reserve a few minutes at the end of the webinar for questions, but if you have any questions along the way, please do feel free to send those in. We will be responding to them during the presentation as well. You can send me a question either using the chat function on Zoom or the Q&A function on Zoom. All right, so one other thing I did want to add is we do have a YouTube channel, and on that channel we will be posting this webinar, and we've posted our past webinars. So if you're interested in a variety of immigration topics and very in-depth, extensive presentations on those, please do check out our YouTube channel. We'll send a link in our follow-up email to you all. All right, again, my name is Dustin, and I'm happy to be your moderator today. We're very fortunate, as I mentioned, to have Ian Scott here today to speak with us. Ian is the founder of Scott Legal, and he has a vast amount of experience processing E-2 visas and the various green card options we'll be speaking about today. To kick everything off, I have a question for you, Ian, that gets at the heart of today's discussion. Does an E-2 visa lead to a green card?
Excellent. Thank you very much, Dustin. And that is a great question. And it's one that often comes up in the E-2 and green card world. And the answer is no, it doesn't. And in fact, there aren't any non-immigrant visas that lead to a green card. What the system in the United States is very different from a lot of other countries. A lot of countries have what's called a points-based system. And that points-based system allows people who, for example, have a certain amount of education, or people who have been in the country for a while, people who have great work experience. Sometimes it looks at age and other factors that that the systems look at to make an assessment as to whether or not someone should be eligible for permanent residency, so a green card in effect. But the way that the system works in the United States is that there really is just a list of green card categories, and you have to apply for them. And if you're eligible, you can apply. So there's nothing that kind of leads to. So if you have one visa, it's not like if you have that visa, and then if you're here for 5 years or 10 years, that you ultimately will get a green card. But instead, you just have to look at the green card category and then look at what the criteria or the requirements are for that particular green card category, and then apply. And so if you see on the slide in front of you, the green card categories are generally broken into 2 different major categories. There are a few more, but for the purposes of this discussion, we're going to focus on these 2 main categories. And that's one being the family-based category. So if you, for example, when I say that you would look at the green card category and see if you're eligible, if you have an immediate relative, so for example, if you have a US citizen spouse, you might be eligible for a green card because of that relationship. Or similarly, if you look at the employment-based categories, if you look at one of the areas, for example, EB1, which we're going to talk about all of the, or 4 of them anyway, we're going to talk about them in more detail. The EB1, they list out what the requirements are for EB1, and if you wanted to apply for that particular green card, if you met those particular requirements, then you would be able to to do that. Similarly, EB-5, it's just a list of very specific requirements that you have to meet to be able to move to that green card category. And in all of these cases, one of the requirements is never that you have to have a non-immigrant visa first. For every single one of these categories, you can apply. You don't even have to be in the United States when you apply for any of these categories. So something to keep in mind. Perfect. So the first green card category, and we do have a number of our clients that kind of move from an E-2 visa to a green card by family, utilizing their family. And the immediate relative category, that particular category in immigration law, is not what you'd normally think of as immediate relative, because we think of immediate relatives as brothers, sisters, etc. But this is defined as a spouse, so a U.S. citizen that wants to marry a foreign national that wants to get that foreign national green card, or a U.S. citizen that is 21 years of age and wants to sponsor their parents. So those are the immediate relative categories, and those are, we do have a number of E-2 applicants. They come in, they set up their business, and they meet the love of their life in the U.S., and then they adjust status or do consular processing to get a green card. So that really is a way that we often see people moving from an E-2 to a green card. The next family-based category is the preference-based category. So that's a lot of the other family-based categories. So for example, if you have a US citizen sibling, if you have a green card holder that wants to sponsor their spouse. So there are a number of different family-based preference categories. Now, the difference between the immediate relative, or the primary difference between the immediate relative and the preference-based categories, is that almost all of the preference-based categories, not all of them, but almost all of them, have a wait for the green card. So immediate relative, there's never a wait in the sense of the green card is always current. Doesn't mean you get it the next day, but it means that the green card is always current, so you can apply for it right away. But just to give you an idea of what this means is that if a US citizen wanted to sponsor their sibling, they would be able to submit an application, but it would be for approximately 14 years before the green card would be available for that particular sibling. So that's that's quite a wait, and that's one of the longer waits. But almost all of the preference-based categories have waits. And the way that this is broken down is, or the way that this works is that there are a certain number of green cards that are available each year, and it's broken down further by country. So the wait for some countries is longer than the wait for other countries. So there's something called a visa bulletin. So whenever you are outside of the immediate relative category, you have to go to the visa bulletin and see whether or not the category is current. And you can also utilize that visa bulletin to see when the government is working on, because when you submit an application, you get something called a priority date, and you can submit something to see when the government, or where the government is with respect to processing your particular application. So the next thing to think about, and that's what's getting at the backlog. So now the next thing to think about, and this really applies to every single green card category that we're going to talk about. So I'm only going to talk about it once, but it applies to every single green card category that we talk about. And that is, there are two ways to apply for a green card. So one is consular processing. So you can be in the United States or outside of the United States, but it means that you plan on going to a consulate to get the green card. And the other way of doing it is something called the adjustment of status process. And that process, you have to be in the United States when you're doing adjustment of status process. And there are certain benefits to that particular process, because when you're in the United States and you file an adjustment of status application, you're permitted to file an application for employment authorization and also travel authorization. Now, one thing to keep in mind is, just a few minutes ago, I talked about categories being current. And when you are in the United States and you're filing an adjustment of status application, the only way you're able to file that application is if your visa category is current. So for example, if you are under the immediate relative category and you're sponsoring your US citizen, a US citizen is sponsoring their spouse, no problem. You can file the I-485 along with your I-130 application. That's a particular application that's filed with that petition. But In the case that I gave you, the example that I gave you where a US citizen sibling wants to sponsor their sibling, then in that particular case, they would only be able to file the I-130 and they wouldn't be able to file the I-485 until 14 years later, or until the visa category, the green card category actually does become current. So as I said, I'm not going to repeat this for every single category that we go through, but the way that the green card system works is that there's an initial application based on the type of green card you're applying for. So if it's family based, it's always going to be I-130. If it's employment based, it's going to be I-140. If it's EB-5 investor visa, it's going to be I-526. So there's always going to be kind of an initial application that looks at the merits of whether or not you meet the qualifications. So if it's U.S. citizen sibling, are you a sibling? So, birth certificate and records at such. If you're marrying a U.S. citizen, are you, marriage certificate and is a legitimate marriage? That's what the I-130 is going to be looking at. And then for all of these processes, whether it's consular processing or I-485, they're all going to be the same. So whether you're filing an I-130, an I-140, an I-526, the next part of the process, if you're in the United States and you're doing adjustment of status, is always going to be the I-485. And similarly, for all of these petitions, if you are filing outside of the United States, the next part of the process is always going to be consular processing. Perfect. So the first employment-based category that we're going to talk about is EB1 extraordinary ability. So now just keep in mind as well that for all of these categories, we do have separate webinars. So we do have an extraordinary ability webinar where we go into more depth on all of the extraordinary ability visas, both the non-immigrant and the immigrant categories. And similarly for some of the other, for example, the national interest waiver that we're going to talk about, et cetera, there are separate webinars. So we do, it's, as Dustin mentioned, we do encourage you to go to our webinar page and sign up for these webinars, or look on our YouTube channel to see recordings of some of these webinars that have already happened. So under the extraordinary ability category, we don't see that many E2s moving to green card under this category, but it is possible to move under an entrepreneur type category. And what we've done is we've highlighted, in what this particular category does, it says a green card is going to be available to somebody who meets at least 3 of the following. Their number, I think 8 criteria that are listed there, and you have to meet at least 3 of them. And the ones that are highlighted, I'm not going to go through each of them separately, but the ones that are highlighted are the ones that probably are going to be most relevant for people who are currently on an E2. When I say highlighted in bold. So for example, the evidence that you command a high salary, you're going to look back at your old jobs and see how much money that you used to make, and then you're going to compare that to what the average person made in that particular job. And that's, if you meet that criteria, you've met one of them. Now, one of the things with this particular green card is meeting 3 of these is unfortunately not enough, because then what the government does is they sit back and they do a very subjective analysis and make an assessment as to whether or not overall they believe you've risen to the level of extraordinary ability. One great thing about the EB1A category is that you can self-petition, so you don't need an employer. So if you do have, if you meet 3 of these criteria and you've done some extraordinary things, and you can meet the second part of the test as well, then it's great, because you actually don't need an employer to sponsor you, which really really reduces a lot of problems. And also, this particular petition is eligible for premium processing. So if you did feel that you qualified, you could get an answer from the U.S. government in as little as 2 weeks. The other great thing about this category is, right now anyway, all of the EB1 is current across all countries. So that's so the green card actually, that's not always the case, but right now it is. The green card is available if you were to utilize this particular category. And as I mentioned before, the 2 ways of getting the green card, either adjustment of status or consular processing. And for this particular petition and a number of the petitions that we're going to talk about, it is going to be filing an I-140, and then after that you're going to be filing an I-485. And you can, for this particular type of petition, file the I-485 concurrently. So if you file the I-140, and as long as the visa category is current, as it is in this across all countries, you could file the I-485 at the same time. Sometimes, depending on the case, we make a strategic decision as to whether or not we file the I-485 at the same time. And that, I think that decision is really a function of how strong we think the case is, because when you do apply for a green card, something we're going to talk about a little bit more as we get through more of the slides. When you do apply for a green card, you really want to make sure that you're approved, because it can impact your if you have to renew, like let's say you don't get approved and you have to renew your E-2, it can impact the ability to renew that E-2, because the government now knows that you want a green card. So the next area is where people, and this is probably the most significant category where we see movements from, well, there are two, but so one of the most significant categories that we see movements from E-2 to a green card, and it's called the national interest waiver. And what this allows you to do, and what really happened with this is in 2016, there was a case that's Danisar, that's the name of the case listed there. There was a case that was decided that really opened up this category for this green card category for entrepreneurs. And the case before that, we really didn't see much movement for entrepreneurs. And generally speaking, getting a national interest waiver was very, very difficult. It was much easier, still difficult, but easier to get EB1. Now I would say that national interest waiver EB2 is a little easier than EB1 based on this case that came out in 2016. So the case, in order to get the green card, you have to meet three prongs, and the first is that the endeavor has to be of national importance. And one of the great things with E-2 cases is that we can point to jobs and the economic impact or benefit to the community of the particular endeavor. So that's that's one great thing. And then we also are going to take a look at what the person is doing. So, if someone is providing consulting services, we might go in depth and look, well, who are they providing consulting services to? Maybe they're providing consulting services to the US government, and we can make an argument that that is in the national interest as well. So we're going to look at these cases very creatively and look to see where exactly it is we can make a strong argument that something is in the national interest. And again, put in a plug, is we do regularly have webinars just on this topic, so just on the national interest waiver. And I encourage you to, again, look at our YouTube channel or sign up for one of these webinars, because it is a topic that just one webinar, it's 45 minutes to an hour going through just the national interest waiver, and we go through these bullet points in a lot more detail with more examples. So with this particular area, we often have expert opinion letters that are written, and the expert opinion letters can talk about why something is of national importance, but it also can talk about the second prong, and that is that the entrepreneur is well positioned to advance the endeavor. And when we look at the second prong, we're really going to be looking at things like the entrepreneur's background, their educational background, their work experience, but also how likely is it that their endeavor is going to succeed. So as to have people invested in the endeavor, do they have contracts in place? How far along are they? So we're going to look at that to make arguments that the person is well positioned to advance the proposed endeavor. And then the final requirement is that the government should waive the labor certification process. And what the labor certification process is for EB2 and EB3, which we're going to talk about them in a second, the differences between this EB2 and the one that we will talk about in a second, is that the government, for those categories, there's another way of getting a green card where you have to show that you can't find a qualified US worker. But the reason they call this a waiver is because it's waiving that particular process. So what we're doing here is we're making arguments that the person, there's a reason the government should do that. And we use all sorts of arguments. We use the argument that the person is extraordinary. We might point to some of the criteria that we talked about in the EB1. We will look at what it is that some of the things we talked about in prong one, why it's of national importance. And then also what we do is for entrepreneurs, one of the biggest arguments that we use here is that entrepreneurs can't compete in that labor certification process because they're company owners. So that this prong, we almost tend to argue that it's not really applicable because an entrepreneur is not eligible to apply for a labor certification process. So they're not, in that sense, they're not competing with anybody. Now, before you look at an EB2, and this applies to EB2 under the national interest waiver or EB2 under the next slide that we're going to talk about in a second, you do have to meet threshold requirements. In this particular category, before we even get into the three prongs, you have to either have an advanced, you have to have an advanced degree, and that, kind of talk about an advanced degree in terms of a master's degree or a bachelor's degree plus 5 years of progressive work experience, or you have to have something called exceptional ability. And that is not to be confused with extraordinary ability, which is EB1, but exceptional ability, there are about 8 criteria related to exceptional ability, and you have to meet 3 of them. And those are a lot less than the EB1 criteria, but so for example, if somebody, so you have the someone with just a high school education that was a tech genius, but they wouldn't meet the advanced degree requirement or the bachelor's plus 5 years of experience requirement. So the only option with respect to doing the EB2 would be if they actually were able to meet the exceptional ability criteria under the EB2 standard. So the next slide, this is kind of a traditional way that people get green cards in the United States, where a company sponsors you for a green card. So when a company sponsors you for a green card, they can sponsor you under EB2 or EB3. So EB2 is the exact same EB2 that I talked about previously, except that EB2 is broken out into 2 areas. It's broken out into national interest waiver, which we just talked about, and then EB2 perm, which is a company sponsoring you for a green card. Now, an E2, one thing to be crystal clear about is an E2 investor cannot sponsor themselves for a green card, and they can't sponsor their families for a green card. But what we do tend to see here is the E2 investor, their spouse can get work authorization, so he or she can get a job with another company. And what we tend to do a lot of is those companies then sponsor the spouse, and then the spouse can get a green card. And when the spouse gets a green card, the E2 investor and children under 21 can join in that process. So that's something we see a lot. That happens often. And the green card process, the sponsorship process, it is quite a complex and long process. It involves filing an I-140. It involves a perm process, which involves proving to the Labor Department that you can't find a qualified U.S. worker. And then of course, it also involves the I-485 process if you're doing adjustment of status, and it can also be consular processing. So this is definitely one that we see often, but as I said, it wouldn't be the E2 investor, him or herself, that is applying for this, because they're not eligible to sponsor themselves or sponsor their immediate family. So this is another significant way we do a lot of these types of movements to green cards, and it's E2 to EB5 investment. Now, the EB5 has some similarities to the E2 in that it's an investor visa, but it probably has more differences than similarities. So the first thing to kind of keep in mind is that if you have an E2 business, then it could be that you'd look at that particular E2 business and see what money you've spent in that particular E2 business. And it could be that some of the money that you've already spent and invested can count towards the EB5 investment. Now, the EB5, the way that it works is that there's an amount that you have to invest. It's a set amount. With E2, as you know, there's no set amount. It depends on the type of business. But right now, the set amount for EB5, and for the purposes of this discussion, we're going to talk about direct investment. So it means that you're doing EB5 for your own company. It is possible for people to be on an E2 and invest in what's called a regional center as well, but we don't see nearly as much of that. With normally the E2 holders, they're entrepreneurs and they like running their own businesses, and they tend to do the direct investment so they can continue to have that control over their business. So right now the amount is $500,000 if you're in an area called a targeted employment area. So it's an area, it's either a rural area or an area where the unemployment rate is 1.5 times the national average, or $1 million. Now, this amount is subject to change because it's only been reduced based on a lawsuit that the government didn't win, and so it could go back up to 900,000 and 1.8 million. But that just kind of remains to be seen. But the one good thing about this is that even if you, wanted to do an EB5 now, and let's say that you started your E2 20 years ago, no problem, because the new commercial enterprise is defined as an entity that started, I believe it's after 1990. I can't remember the exact date, but it's some time ago. So you are going to be able to go back and look at what amount you've invested in the past, and some of it you may be able to count towards your E2. And because the investment can be made over time, then you can make additional contributions to come up to the 500,000 or the 900,000 or the 1 million or the 1.8 million, depending on which area that you're in. A few things to keep in mind is that some of the things that you can count towards investment in E2, you can't for EB5. So for example, for EB5, you can't count administrative or legal fees. The other thing is that with E2, that's fine if you want to, for example, buy a business. Like, let's say you have there's a restaurant and you want to give someone $500,000 for a restaurant, and you give them cash and they give you the shares or they give you the assets. That's no problem under E2, but it is a problem for EB5. EB5 requires that the money is invested actually in the business, and that money that's invested in the business has actually created US jobs. So definitely the exercise with E2 and EB5 is going through and seeing what is it that we can count, because in the example where someone buys a business for 500,000, that may still be eligible for EB5, but the person would have to then invest another 100,000 after they've paid the seller. They would have to invest another 500,000 in the business, and that 500,000 would have to go to creation of US jobs. The other thing to keep in mind is that a lot of people have an E2, and this E2 might be very successful, and they think, okay, well, my E2's made $3 million, so and last year I spent over $1 million, so now I'm eligible for EB5. But it doesn't work that way. Unfortunately, the revenue and or retained earnings that you have in the company cannot be counted towards investment. Investment is your personal investment that you have. So maybe if you paid yourself out money and then reinvested in the company, it's possible that that could count, but the investment is very specific to your personal investment. It's not money that the company has made and spent. So something to keep in mind. The other thing to keep in mind with EB5 that's very different from E2 is that the source of funds analysis for EB5 is very different from E2. The regulations look the same on paper for E2 and EB5, but the exercise for EB5 is probably 100 times more complex and more detailed than the exercise for E2. For E2, we tend to provide very little information related to where the money came from, but under EB5, it's almost like an extensive audit of where the money came from and detailed tracking of where the money came from. So that's something that that you have to keep in mind, because even if you have an E2, if you did your E2 10 years, 15, 20 years ago, it doesn't matter. You still have to provide extensive documentation of where the money came from, and that in some cases that's not possible. So and if you can't provide the documentation of where the money came from, you can't include that amount as the investment. And for EB5, there has to be equity. You can't just like loan a company money and say, I want a green card. It has to be equity at risk, which means that you have the risk of losing all of your capital. So it can't be a loan. The other big difference with EB5 from E2 is that the job. So E2, you can have contractors, you can have part-time people, you can have job share, a mix of different things happening, no set amount of jobs that have to be created. But for EB5, it's 10 full-time jobs. So not part-time jobs, not contractors, and the jobs have to be for green card holders and US citizens. So that's very different from E2. And the other kind of big thing is the jobs have to link to the investment. So you can't, for example, let's say I'll use the example again where you buy a particular company and you give the money to the seller, and the company already has 10 full-time employees. None of those employees count from the EB5 perspective, because your money didn't create those jobs. Those jobs had already been created, and so in order for it to count, you'd have to invest another $500,000 and then utilize that money to hire 10 more people. So you can't even use the money just to pay the existing people that are there. you'd have to hire 10 more people. So there has to be a linkage or a nexus between job creation and the money that you invested. And it is quite an extensive exercise documenting the full-time positions of the qualified workers. So for the EB-5 filing, as I said, there's an initial petition. The other, family-based, it's I-130. Employment-based, it's I-140. And for EB-5, it's I-526. One big difference between I-526 and the I-130 and the I-140 is that you can never file the I-485 concurrently. The I-526 has to be approved before you can file an I-485 petition. So that's something that is different, and that becomes a big problem because I-526 petitions take 2 to 5 years to be approved. And lately what we've been doing, and Dustin has done a lot of this, is suing the US government because the time that they're taking to adjudicate petitions is very long, right? So we tend to wait a couple of years, but even, probably reasonable to even sue before that, because the processing time is quite extensive, and it is a business. And I think it's probably not Congress's intent that people were sitting around in limbo for a couple of years when they're, deciding that they want to invest in the United States. So.
Great. And Ian, so we have the EB-5 example coming up.
Yeah, we could skip by that. Yeah.
Perfect. And for those on the webinar, I haven't received any questions. If there is anything on your minds, please do feel free to send those in by chat or the Q&A function.
Perfect. And everyone's going to get a copy of the presentation. So if anyone has questions about the EB-5 example that's listed there, definitely feel free to reach out. So some of these we've talked about already, but we'll touch on them a little bit here again. Is timing consideration. So especially petitions that are very long dated, like EB-5, it's going to be years. So you have to, when you file an EB-5 petition, when you file an I-140 petition, if you don't file an I-485 with it, with EB-5 you can't, but an I-140 you may or may not be able to, depending on which country you're from and which category. It doesn't provide any basis to stay in the US. Those petitions on their own don't provide a basis to stay in the US. So you have to be careful when you file and make sure that you're planning everything so that you always have underlying status in the US. And as I said, in particular, when particular petitions take a long time, or if you're from certain countries. So for example, the EB-5, China, that particular visa category is not current, on top of the long wait that you would just take to adjudicate, that government's taking to adjudicate petitions anyway. The other thing that you have to keep in mind is that when the government is, when you do signal that you want a green card, then if you have to renew your non-immigrant visa, and your non-immigrant visa is not what's called a dual intent visa, then you may have difficulties renewing it because the government will think that you're coming to the US to adjust status, and then may not end up renewing the actual visa. So you could be, you could be out of luck because of that. You could have a situation where your parent, for example, like you could have a US citizen parent that wants to sponsor their child over 21, and that's not an immediate relative category. So that's not current. So, but, let's say we did one of these recently where we did an E-2 visa for a son, and the visa was the green card was going to be current within 3 years, and we were worried that when the son went to the consulate that they may raise that as an issue, but luckily they didn't. But it's something that they absolutely could raise as an issue and say that they're not going to issue the E-2 because the person's eligible for a green card, and they feel that the person may adjust status in the United States. So that's something to keep in mind. The other thing to kind of keep in mind is, we have people like parallel green card strategies. You can apply for multiple green cards at the same time. We often have people that apply for EB-1 and EB-2 national interest waiver at the same time because some of the aspects of the two are the same. But definitely it's something to consider. Some people want a few bites at the apple, and it is common to do. And then the last point on this slide is just that planning is the key here, because I think that if, even the best planning occurs, day one when you get your E-2, because you can, if for example you are interested in a green card and you want to do EB5, then you want to make sure when you do your E2, for example, that you're actually have documented the source of funds in a manner that's actually going to be satisfying for the EB5, right? You don't want to have to go back 10, 15 years later and fix things, and it may be at that point it may be too late to fix. Perfect. Yeah. So I know, Dustin, you said you don't have any questions.
Yeah, absolutely. So no questions have come in so far. So Ian, I do want to thank you for taking the time to speak with us today. For those on the webinar, I'll just repeat what I said earlier, that after this webinar, you'll be receiving an email from us, which will have the presentation. It'll also have a link to the YouTube channel that Ian also spoke about. And on our YouTube channel, you'll find webinars on a variety of topics, as well as shorter videos. So please, if you're curious at all, visit that, our channel. And if we can be of any assistance along the way, please don't hesitate to reach out to us directly. Ian, thank you for taking the time and sharing your wisdom with us. To wrap this up, one question just came in. Someone from India, can they come to the US on an E-2? Great question, Ian.
Sure, sure. So we do have clients that are Indian nationals, and they have purchased citizenship from Grenada. As you know, I think that particular country is an E2 country, which offers an E2 visa for 5 years. So Dustin is actually working on a case with a client right now who we've submitted the application to the US consulate in, I can't remember which one, but we've submitted the application. And that's how the applicant is eligible. So because Indian nationals are not eligible for E2 visas, but that is, I think the citizenship, it's a couple $100,000 that you can purchase it for. There are other countries as well, like Turkey is an E2 country, and I think they offer a similar program, but I think that the easiest, fastest one happens to be Grenada. Yeah.
Okay, so apparently they meant to say L1. How feasible is it for someone who is only selling services, not products? I
Yeah,
wonder,
well,
yeah.
yeah. So I think that the L1 is it's a different webinar, unfortunately, that to this one. So it's yeah. So I'll just leave it at that. Yeah, because
Yeah,
it's
so
L1 is a non-immigrant visa, so it's just not as I said, that's just a different webinars. Right?
yeah, so please do take some time on the YouTube channel we mentioned. I believe there is an L1 video. So Sven, the question about E2 investments counting toward the EB5, we did touch on that. So when we send out the link, please do check that portion. Ian, I don't know if you have anything to quickly add
No,
to that.
I think that's right. We did touch on that. I think the slide where we talked about EB5, we talked about some of the things that can be included and other things that can't, right? So I think that those are it, and what it is the exercise really is one of going through item by item and assessing whether or not you can include, like, because let's say you're trying to get to the 500,000, going through item by item, expenditure by expenditure, and assessing whether or not that particular expenditure can be included, from a perspective of the regulations, like, so for example, legal fees and administrative costs cannot be included, but also in terms of, do you have a clear source of funds trail for that particular number or amount. So that's the exercise that many E2 to EB5 applicants go through.
Great. And then another question from Miguel. Mom is a US citizen, brothers are green card holders. What is the best way for me to move to the US? Sponsorship from a company or through any relative process? Miguel, Ian touched earlier on the visa bulletin, which you'll probably want to check out. That's published monthly. If you Google visa bulletin for, I believe October's just came out, October 2021, you'll get a sense of the different timing, the amount of time you'd have to wait for a green card in each of those categories. And then, you'd have to think about regarding sponsorship, whether you do have an employer lined up and what really just is feasible for you. But Ian, I don't know if you wanted to add anything.
No, I think that's exactly right. I think that the visa bulletin will show you, like, none of the categories that you mentioned are current. So if you have a U.S. citizen parent, that category, I think it's 6 or 7 years out. So to look at that, but then, if you're comparing it against employment based, then you have to look at we went through all of the categories where employment based would be applicable for a green card. So you would have to look at those employment based green card categories and see whether you're eligible for them, because at least those are current, right?
Mhm.
Like like if you were eligible under EB2 and EB3, if as long as you were not from, depending on where you're from, they're current. So depending on but again, the visa bulletin covers both family based and employment based. So if you're applying under EB3, you would look at the visa bulletin. It's broken down by country. So yeah, and then you'd look at you compare that to your prospects with respect to those particular visas, right? Categories. So are you are you eligible? Like, if you're looking at EB1, it's pointless looking at it unless you have extraordinary ability. Or if you're looking at EB2 and EB3, it's pointless looking at it unless you have a company that's willing to sponsor you. Or if it's national interest waiver, you have to be doing something that's in the national interest.
Perfect. So Ian, thank you again. We will leave it at that. And please do look forward to our email and the links to the additional information. Thank you,
Perfect.
everyone, very
Excellent.
much.
Thank you. Thanks a lot.